ನಿಮ್ಮವನ್ ಸುಳ್ಳ ಕೋರ್ಟ್ ಮುಂದೆ ಸುಳ್ಳು ಹೇಳಿದಾನೆ, ತಗೊಂಡಿಲ್ಲ ಅಂತ ಏನ್ ಗ್ಯಾರಂಟಿ ಅದಕ್ಕೆ? ಕೋರ್ಟ್ ಮುಂದೆನೆ ಸುಳ್ಳು ಹೇಳ್ತಾನೆ, ನೆಂಟನ್ನೇ ನೆಂಟ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ದುಡ್ಗೋಸ್ಕರ. ಅವನ್ ಹೆಂಗ್ ನಂಬೋದು?
ಸುಳ್ಳು. 2015 ಅಕ್ಟೋಬರ್ ಮೊದಲ ವಾರದಲ್ಲಿ ಸೋಣ್ಸೋ
ಅಂತ ಸುಳ್ಳ ಅಂದ್ರೆ ನಿಮ್ಮವನು, ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದೂರದ ಸಂಬಂಧಿ ಅಂತೀರಿ.
ಅಲ್ಲ, ಅಡ್ಮಿಟೆಡ್ ಮೈ ಲಾರ್ಡ್.
ಪ್ಲೀ ರೆಕಾರ್ಡ್ ಮಾಡುವಾಗ ಏನ್ ಹೇಳಿದಾನೆ ನೋಡಿ, ಏನ್ ಹೇಳಿದಾನೆ ನೋಡಿ ಪ್ಲೀ ರೆಕಾರ್ಡ್ ಮಾಡುವಾಗ.
ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇವನ್ ಯಾವನ ನಾನು ನೋಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ.
ಅಲ್ಲ ಏನೇನೋ, ಬಟ್ ಆಫ್ಟರ್
ಏನೋ ಅಲ್ಲ ಅಂತ ಕಳ್ಳಂಗೇನ್ರಿ ಹೇಳೋದು?
ಸರಿ,
ಏನೋ ಏನ್ ಬಂತಲ್ಲಿ? ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳ್ತಾ ಇದ್ದಾನೆ, ಜ್ಞಾನ ಬೇಡವಾ? ಅಲ್ಲಿಂದ DW1 ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಪ್ಕೋತಾನೆ, ಹೌದು ನಮ್ ನೆಂಟ ಅವನು ಅಂತ. ನೋಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ. ನೋಡೇ ಇಲ್ದಿರೋ ನೆಂಟನೇನು?
ಅಲ್ಲ, ಇವೊಂದು ಮೈ ರೆಸ್ಪೆಕ್ಟಿವ್ಲಿ ಸಬ್ಮಿಷನ್
ಸ್ವಲ್ಪ ಇದನ್ನೆಲ್ಲ ಬಿಡ್ಬೇಕು. ಕೋರ್ಟ್ ಮುಂದೆ ಯಾವ್ದಾದ್ರು ಒಂದ್ ವಿಚಾರ ಹೇಳಿದಾಗ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡಿರುವಾಗ ಬಾಯಿಂದ ಸತ್ಯ ಬರ್ಬೇಕು. ಪ್ಲೀ ರೆಕಾರ್ಡ್ ಮಾಡುವಾಗ್ಲೇ ಇವ್ನು ಯಾವನ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳೋದು, ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ದೂರದ ನೆಂಟ್ರು ಅಂತ ಹೇಳೋದು, ಅವ್ನು ಒಪ್ಕೊಳ್ಳೋದು, ಬ್ಯಾಂಕಿಂಗ್ ಕೆಪಾಸಿಟಿ ನೀನ್ ಕೊಡಕ್ಕೆ ಯೋಗ್ಯತೆ ಇಲ್ಲ, ನೀನ್ ಪಾಪರ್ ಅಂತ ಹೇಳ್ತೀರಿ. ಅವ್ನು 7.5 ಲಕ್ಷ ರೂಪಾಯಿ ಅಗ್ರಿಮೆಂಟ್ ತಗೊಂಡ್ ಬಂದಿರೋದನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ಹಾಕ್ತಾನೆ. ಈಗ ಯಾರು ಅಂತ ಗೊತ್ತಾಯ್ತಲ್ಲ ಪಾಪರ್ರು. ಸುಮ್ನೆ ಇವೆಲ್ಲ ಮಾತ್ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ. Anything else? Read the judgment of the trial court at 2021. ಓದ್ಕೊಂಡ್ ಬಂದಿರುತ್ತೆ ಕೋರ್ಟ್ನವರು ಎಲ್ಲಾನು.
ಅಲ್ಲ, that reason I will settle the matter.
No, sir. You are bound to settle because this money you are sitting from 2018. 4 ಲಕ್ಷ ರೂಪಾಯಿನ 4 ಲಕ್ಷ ರೂಪಾಯಿ ತಗೊಳಕ್ 6 ವರ್ಷ ಕಾಯ್ಬೇಕಾ? Look at section 80.
ಸಪೋಸ್ ನಾವು ತಗೊಂಡಿದ್ದೆ, ನಾವು ರೆಡಿ, ಬಟ್ ಏನೋ ಚಿಕ್ಕ ಓನ್ಲಿ
ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ. ನಿಮ್ಮವನ್ ಸುಳ್ಳ ಕೋರ್ಟ್ ಮುಂದೆ ಸುಳ್ಳು ಹೇಳಿದಾನೆ, ತಗೊಂಡಿಲ್ಲ ಅಂತ ಏನ್ ಗ್ಯಾರಂಟಿ ಅದಕ್ಕೆ? ಕೋರ್ಟ್ ಮುಂದೆನೆ ಸುಳ್ಳು ಹೇಳ್ತಾನೆ, ನೆಂಟನ್ನೇ ನೆಂಟ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ದುಡ್ಗೋಸ್ಕರ. ಅವನ್ ಹೆಂಗ್ ನಂಬೋದು? ದುಡ್ಡಿಲ್ದೇರ ಅಷ್ಟೇ ಹೋಯ್ತು, ನೆಂಟ ಅಂತ ಅನ್ಬೇಡ್ವಾ? ಜಡ್ಜ್ ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರೆ ಇಲ್ಲ ಸ್ವಾಮಿ ನಮ್ ದೂರದ ನೆಂಟ ಅಂತ ಹೇಳ್ಬೇಕು ತಾನೆ. ಇಲ್ರಿ ಇವ್ನ ಯಾವನ ಗೊತ್ತೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ, ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಅಂತವನ್ಗೇನ್ ಮರ್ಸಿ ತೋರ್ಸೋದು? ಚಿಕ್ಕಬಳ್ಳಪ್ಪನ ನೀವು ಸಾಕ್ಷ್ಯ ಕರ್ಸಿದ್ರೇನು ಕೋರ್ಟ್ ಮುಂದೆ?
ಆಕ್ಚುಲಿ ನಾನ್ ಕೇಳಿದ್ನ, ಅವ್ರು ನೀವು ಕರೆಸ್ತೀರಾ ನಾವು ಕರ್ಸಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರು ಕೇಳಿದ, ನಾನ್ ಕೇಳಿದ್
ಯಾಕೆ ಕರ್ಬೇಕು? ನೀವು ತಾನೇ ಕೊಟ್ರು ಚಿಕ್ಕಬಳ್ಳಪ್ಪನ್ಗೆ, ಅವ್ರು ಯಾಕೆ ಕರ್ಸ್ಬೇಕು?
ಆಲ್ರೆಡಿ ಸೋ ಮೆನಿ ಕೇಸಸ್ ಸೇಮ್.
ಹೌದು, ಚಿಕ್ಕಬಳ್ಳಪ್ಪನು ಶೋಭನ್ ಮೇಲೂ ನೀವು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಅಲ್ವೇ? ನಿನಗ್ ಕೊಟ್ಟು ಚೆಕ್ ತಗೊಂಡೋಗಿ ಇವ್ರಿಗೆ ಹಾಕಿದ್ಯಲ್ಲ, ಇದೆಲ್ಲ ಬೇಕಾಗಿತ್ತ? ರವಿಗಿಂತ ಕೇಸ್ ಹಾಕ್ಸಿದ್ಯಲ್ಲ ಅಂತ ಕೇಳ್ಬೇಕಾಗಿತ್ತು.
ನಾಟ್ ಟೇಕ್ ಎನಿ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಚಿಕ್ಕಬಳ್ಳಪ್ಪ.
ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ. ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರೇನೆ ಸುಳ್ಳು ಹೇಳ್ತಾರೆ, ಅಂತವನ್ಗೇನ್ ಮರ್ಸಿ ತೋರ್ಸೋದು? ಇದೆಲ್ಲ ನಿಂತೋಗ್ಬಿಡ್ಬೇಕು, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಕೋರ್ಟ್ ನಲ್ಲಿ ಬಂದಾಗಾದ್ರೂ ಸ್ವಲ್ಪ ಸತ್ಯ ಹೇಳೋದನ್ನ ಕಲಿಬೇಕು ಅವರು. ದುಡ್ಡು ತಗೊಂಡಿರೋದು ಬಿಡೋದು ಸೆಕೆಂಡ್ರಿ. ನೆಂಟನ್ನೇ ನೆಂಟ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾನ ನಾನು. ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಪ್ಸಿದಿರಿ ನೀವು, ಹೌದು ಅವ್ನು ದೂರದ ಸಂಬಂಧಿ ಆಗ್ಬೇಕು ಅಂತ. ತಿರ್ಗಾ ಇವನ್ ಸಾಕ್ಷಿಯಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಇವ್ನು ಯಾರೋ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಅಂತ ಎವಿಡೆನ್ಸ್ ನೇನು ಓದ್ಬೇಕಾ? ನಿಮಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ವ ಅವತ್ತಿಂತ ನಾವು ಪ್ಲೀ ತಗೊಂಡಿದೀವಿ, ಇಂಥದ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದೀವಿ, ಅದರಿಂದ DW1 ಅಫಿಡವಿಟ್ ಹಾಕುವಾಗ ನಾವು ಅವ್ನು ಒಪ್ಕೋಬೇಕು ನೆಂಟಸ್ತನ ಅಂತ? ಅದೇನೋ ಬಿಡಿ, ಅವನಿಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ, ಲಾಯರ್ ಗೊತ್ತಿರ್ಬೇಕಲ್ವಾ? ಕೇಳಿದಾರೆ ತಾನೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಏನೋ ಮನುಷ್ಯ ಅವ್ರಿಗೇನೋ ಗಲಾಟೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಅದು ಅವ್ರೇನೋ ಯಾಕಂದ್ರೆ ಚಿಕ್ಕಬಳ್ಳಪ್ಪ ಇವ್ರಿಗೂ ಸ್ವಲ್ಪ ಗಲಾಟೆ ಆಗಿ ಅದಕ್ಕೋಸ್ಕರ ಇವ್ರ ಕಡೆಯಿಂದ
ಊರಲ್ಲಿ ಚಿಕ್ಕಬಳ್ಳಪ್ಪ ಕೊಡಿರಿ, ನಮ್ಗೇನ ಬೇಕು?
ಅಲ್ಲ, ಅದರಿಂದ ಇವ್ರ ಕಡೆಯಿಂದ ಚಿಕ್ಕ ಹಾಕ್ಸಿರೋದು ಅಂತ.
ಅದೆಲ್ಲ ಇರೋದಿಲ್ಲ, ಸುಮ್ನೆ ಅವೆಲ್ಲ ಹೇಳೋದಷ್ಟೇನೆ.
ನೀವು ನಾಟ್ ಟೇಕ್ ಎನಿ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಚಿಕ್ಕಬಳ್ಳಪ್ಪ.
ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ, ವಾಟ್ ಈಸ್ ಯುವರ್ ಗುಡ್ ನೇಮ್ ಸರ್?
ರಾಘವೇಂದ್ರ.
ಶ್ರೀ Raghavendra NR and CG Gopal Swami, accused who suffered an order of conviction in CC number 5012 of 2018 for the offence punishable under section 138 of the Negotiable Instrument Act and ordered to pay fine of rupees 4,05,000 as against the check amount of rupees 4 lakhs and out of the fine amount, sum of rupees 4 lakhs to be paid as compensation, balance sum of rupees 5,000 towards the defraying expense of the state, confirmed in criminal appeal number 574 of 2021 has preferred this revision petition. Next para. The facts in brief which are utmost necessary for disposal of the revision petition are as under. Next para. A criminal prosecution came to be launched by the complainant alleging that accused issued a check in a sum of rupees 4 lakhs towards the repayment of the hand loan, which on presentation came to be dishonored with an endorsement, funds insufficient. First, there was no compliance to the callings of the legal notice and therefore he sought for action. Next para. Learned trial magistrate, after recording the plea, summoned the accused. After completing the formalities, summoned the accused and recorded the plea. First, accused pleaded not guilty and also pleaded that complainant is a stranger to the accused. First, next para. Thereafter, in order to prove the case of the complainant, the complainant got examined himself as PW1 and placed on record 7 documents which were exhibited and marked as exhibit P1 to P7. First, detailed cross-examination of the complainant did not yield. Detailed cross-examination of the complainant by the accused did not yield any positive material so as to disbelieve the version of the complainant or to dislodge the presumption available to the complainant under section 139 of the Negotiable Instrument Act. First, next para. Accused statement as is contemplated under section 313 CRPC was recorded, wherein accused has denied all the incriminatory circumstances. First, to rebut the presumption available to the complainant under section 139 of the Negotiable Instrument Act, the accused got examined himself as the DW1 and placed on record statement of account to show that he had transaction with Chikka Pillappa and his wife Shobha, and the amount that has been borrowed by the accused from Chikka Pillappa and Shobha has been repaid. First, thereafter, trial magistrate heard the parties in detail and convicted the accused as aforesaid and imposed the sentence. Convicted the accused and imposed the sentence as aforesaid. Next para. Being aggrieved by the same, accused preferred an appeal. In criminal appeal number 574 of 2021, first, learned judge in the first appellate court, after securing the records and hearing the parties in detail in the light of the appeal grounds, dismissed the appeal by judgment dated 6th October 2023. First, thereafter, accused is before this court. Next para. Sri Raghavendra NR, learned counsel for the revision petitioner, reiterating the grounds urged in the revision petition, vehemently contended that both the courts have failed to appreciate that there was no transaction between the accused and the complainant. Full stop. He also pointed out that complainant admits that accused is a far relative of the complainant and there was a transaction between full stop. He further argued that the accused had a loan transaction from another farmer, namely Chikka Pillappa and his wife Srimati Shobha, and the checks that has been given by the accused in favor of Chikka Pillappa has been misused by the complainant on account of some differences between the Chikka Pillappa and accused, and got a false case foisted which has not been properly appreciated by both the courts and sought for allowing the revision petition. He also pointed out that in the absence of any lending capacity on behalf of the complainant, the rebuttal, the presumption available to the complainant under section 139 of the Negotiable Instrument Act could not have been invoked in favor of the complainant and sought for allowing the revision petition. Per contra, C.G. Gopal Swami, learned counsel for the respondent, supports the impugned judgments. Having heard the parties in detail, this court perused the matter law on record meticulously. Next, on such perusal of the matter law on record, it is crystal clear that the signature of the accused in the dishonored check is that of the accused, and therefore, initial presumption is in favor of the complainant. First, insofar as the lending capacity is concerned, accused has the complainant has placed on record the statement of account whereunder, the prospective purchasers of the land of the complainant has deposited some rupees 7,50,000 as the advance amount, and the same is reflected in the statement of account filed by the complainant at marked at exhibit P7. Full stop. Next para. Therefore, the contention urged on behalf of the accused that the complainant had no lending capacity cannot be countenanced in law. That would full stop. Accordingly, the presumption raised by the trial magistrate confirmed by the first appellate court in favor of the complainant as is contemplated under section 139 of the Negotiable Instrument Act needs no interference by this court, that too in the revisional jurisdiction. Next para. No doubt it's a rebuttable presumption. First, to rebut the presumption available to the complainant, the accused got examined himself as DW1 and has stated that he does not know the complainant and is a stranger to him. First, it is noticed that in the cross-examination of PW1, on behalf of the accused, it has been mentioned that the accused is a far relative which has been admitted by the complainant. In the teeth of such a suggestion made by the accused, how accused could go to the extent of deposing before the court, that too on oath, that complainant is a stranger, is a question that remains unanswered on behalf of the accused. Further, he has put up the theory of the misuse of the check by Chikka Pillappa and his wife Shobha. First, next para. To substantiate the said theory of misuse, neither Chikka Pillappa is cited as a witness nor Shobha is cited as a witness. Mere marking of the statement of account of the accused at Exhibit D1 would not be sufficient enough to rebut the statutory presumption available in favor of the complainant. First, therefore, recording of order of conviction by the trial magistrate confirmed by the first appellate court needs no interference by this court, that too in the revisional jurisdiction. Next para. Having said this, both the courts have erred in imposing sum of rupees 5,000 towards the defraying expense of the state, as the list is privy to the parties and no state machinery is involved. To that extent, the case is made out for interference. Accordingly, following order, revision petition allowed in part. Eradu. While maintaining the conviction of the accused for the offence punishable under section 138 of the Negotiable Instrument Act, sum of rupees 4,05,000, fine amount of rupees 4,05,000 imposed by the trial court confirmed by the first appellate court is reduced to sum of rupees 4 lakh. Full stop. Entire sum of rupees 4 lakhs is to be paid as compensation to the complainant on or before 31st of July 2024.
1 month time. Already 1 lakh, 1 month time. Next month, 15th or 16th.
On or before 21st of July 2024.
8th, 21/8, my lord. August.
I am saying 4 days.
Sorry, my lord.
You deserve that. You don't deserve any further. Nentane nenta alla annೋನ್ಗೆ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಿ? All right. 15th of August.
ಇನ್ನೊಂದು ಲಕ್ಷ ಅದು ಎರಡು.
All right, 15th of August. 15th of August 2024, failing which the accused shall undergo simple imprisonment for a period of 1 year. First, amount of rupees 5,000 imposed by the trial magistrate confirmed by the first appellate court towards the defraying expense of the state is hereby set aside.